There we go. So we're now broadcasting to LinkedIn and also via Zoom. So I wanted to officially welcome everybody to this webinar and say thank you so much for joining us. We're here to talk about Brexit and the impact of Brexit on cross-border workers. We are going to start with the definition of cross-border workers because that's one of the biggest problems. And then we're going to get onto some of the challenges and our recommendations to solve them. But before we start getting into the details, I have a few tiny little housekeeping items, which are, number one, everybody's obviously on mute at the moment. We can't see any of you guys. You don't have your cameras on. If you've got questions or you've got comments or anything you want us to talk about, please put those into the Q&A box or the chat window and we'll try to get to them live, because the whole point of doing a live webinar is that we can answer your questions if possible. If we don't have time to get to them, then we will try and answer them afterwards. And I would be remiss not to put in a little plug for my immigration forum, which is on the OWL immigration website. So if you've got any immigration questions, actually, but especially those about Brexit and cross-border workers, please come to www.owlimmigration.com and join the Immigration Parliament there. The big advantage of that is that you can have your questions answered by experts from all over the place, and also that your answers are then there for everybody to be able to see and benefit from, which I love, because anything that saves our inboxes is good in my book. So I'm Sophie King, I'm the MD of OWL. I love immigration and I love my colleagues in it. And before we start talking about cross-border workers and Brexit, I'm going to ask everybody on my beautiful panel to introduce themselves. So we should probably go in alphabetical order. So Agnieszka, do you want to go first?
Hello everyone, I am Agnieszka Bukowska-Fannen and I am an immigration expert from Poland. I own a consultancy who deals with corporate immigration issues such as work and residence permit, and we've been operating since 2003.
Thank you. B, you're next. We're doing alphabetical in order of first name because we're so friendly and informal.
Lucky I know my alphabet in that case. Thanks, Sophie. Hello, everybody. I'm B. Rudki. I'm the founding partner of the Nathanson Partnership Immigration Services. By way of brief background, I've spent over 20 years in the immigration industry, from UK government, the Home Office Immigration Department, to Big Four, relocation, and the legal sector as well. We provide services to corporates, SMEs, multinational organisations and private individuals as well. If you do have a moment now, obviously, please do connect with me on LinkedIn, and any questions that come up, if we can't answer them during this session, obviously, please do send the query through to OWL Immigration, as the Immigration Parliament, as Sophie has indicated, but also obviously do contact me via LinkedIn or our website, which is nathansonpartnership.com. Thank you.
Sybille.
Can I go next?
Yes. I'm like, SG, what's the alphabet?
I'm Sybille Schneider. I'm based in Germany and I'm an immigration expert as well. Over the last 20 years, I worked for the first 10 years in immigration for service providers in Germany. And now, during the last 11 years, I'm part of the global immigration team at Cognizant. And we are looking after travels into Europe, and we are supporting the assignments of our employees there. And I'm very much looking forward to that session. Thank you for inviting me, Sophie.
Always a pleasure.
Good afternoon. First, Sophie, thank you for inviting me. My name is Tanel Feldman, partner in Immigration Law Associates based out of Brussels. I think it's pretty enough. Let's go to Sophie.
Thank you. So, so one of the reasons I'm so pleased about this panel that we have is we've got B is from the UK expert. Agnieszka is representing the European side with Poland, as is Tanel from, I mean, you may be in Brussels, but I think all there is to know about pretty much every place in Europe. And also Tanel is a social security expert as well, which is important. And then Sybille has worked in immigration for so many years across the whole region and has both the service provider and the in-house point of view. So I just feel like we've got it really well covered. But I just want to emphasize again that we do want your questions and your comments as well, because these sessions, we want them to be as kind of interactive and useful as possible. We don't want to kind of lecture in the dark, as it were, So anyway, I do talk too much and I'll try not to. So the first thing that we wanted to start with was the definition of cross-border workers. And this seems to me to be so important because it's so misunderstood. And in fact, somebody said to me the other day, I said, do you want to come to my webinar? And he said, oh, it's a bit niche for me. And I actually put this on LinkedIn because I was like, it's not niche. How could you say it's niche? But people think it's niche because I think the term cross-border sounds sort of special, you know, and frontier worker sounds really special. It's like literally sounds Star Trek-y. But all we're talking about here is people who reside in one place but work regularly in another place. That's what we're talking about. That's what a cross-border worker is. And specifically today, we are talking about cross-border workers in the context of Brexit. So we're not talking about, you know, an American who lives in France but sometimes works in Belgium. That is a very interesting subject and something that should be looked at, but it's not what we're going to cover today because we would really be here all night. So we're talking about people who reside in one country and work in another, and this in the context of Brexit, we are particularly referring to EU nationals who live in the EU and work regularly in the UK. And we're talking about UK nationals who live in the UK or in one EU member state, but work regularly in a different EU member state. Because we're mainly looking at this, I would say almost exclusively looking at this from the point of view of immigration. There is a different definition when you think of social security. So before we really get into it, I actually I was going to go around the room and ask everybody, is this definition, you know, is this what you would tell your clients or your colleagues, and what do you have to add to it? And I thought we should probably start with Tanel because I haven't covered the social security side of things at all, and I think you need to do that for us.
Thank you, Sophie. So first, to frame, I will bring on exclusively frontier worker. Okay, I could see a question which is there is a formal definition of cross-border worker. No, I am not aware of such a definition. In my view, cross-border worker, which is eventually used in many situations, it's a frontier worker. Now, what is a frontier worker point of view from the perspective of social security? We have the classical definition, Article 1F, Regulation 883/2004, which is an employed or self-employed person who is working in one member states and resided in another member states to which he returns daily or at least once a week. Now, there is another definition which I would call as a practical definition in order to really understand the concept of frontier worker from the perspective of social security. And that definition, it sounds even simple. If we have the member state competent for social security and the member state of habitual residence are two different member states, so are not the same member states, then we have a frontier worker point of view, social security. That definition is generally, so for the moment, I'm not touching Brexit, I'm talking in general. Now, because we had this question, I will spend probably 10 seconds more to explain. It's not necessary, I mean, there are atypical cases of frontier workers. For instance, we have reverse frontier workers. We have the famous Blueski case in which German national was initially working in, residing in Germany, working in Switzerland, then employment was transferred to Germany and residence to Switzerland. So that is a reverse frontier worker. And we have a very interesting, very rare case of posted worker, which are also frontier workers. Again, I'm bringing point of view strictly social security, which, for instance, imagine a Belgian worker which will be posted by a Belgian employer to work in Italy for an anticipated period of 4 years, which is beyond the 24 months permitted under Article 12. So the Social Security competent authority in Belgium will address the topic under Article 16, reaching out to the authority in Italy. So imagine the frontier worker will cancel the lease in Belgium, will cancel registration in Belgium. The A1 will be issued under Article 12, and the habitual residence from the perspective of Article 11, 987/2009 will be in Italy. So that is a very rare case of posted worker who is also a frontier worker. Now, okay. Going to Brexit, it's not complex. We have Brexit, we have withdrawal agreement, and we have the TCA, the Trade and Cooperation Agreement. Now, the definition under the withdrawal agreement for those who are beneficiaries of the withdrawal agreement, it's the one from Article 1F Regulation 883/2004. Practically, it's not the definition from that, but the regulation applies for frontier workers which are who are beneficiaries of the withdrawal agreement. Now, from the perspective of the trade and cooperation agreement, we have two situations.
Yeah.
Situations which that involve at the time UK and the EU, and in that case, the Social Security Coordination Protocol from the TCA would apply, and then the definition will be the same, but it's not means that the regulations, the Social Security Coordination will apply, but the definition from the protocol is the same as Article 1F. And we have a second situation in which which are confined to the EU exclusively.
Yeah.
And in such cases, the Social Security Coordination regulations apply by virtue of another regulation, which it's a regulation 1231/2010, which is very simple. A third country national lawfully residing in one member state and who is not subject to the Social Security Coordination regulations by virtue of his nationality is subject by virtue of his residence unless the situation is confined to one single member state. So by virtue of this regulation, situations under the TCA which are confined to the EU will finally fall under so the definition will be the definition from Article 1F Regulation 883/2004. So that is as regards very, very brief and very as regards the definition point of view social security, which a last topic is very important to underline, to be careful, point of view withdrawal agreement. We have two definitions. Withdrawal agreement, the definition point of view, right of entry, work, stay, exit, I'm talking about from it's one, and the definition from the perspective of social security, it's another one. Okay.
Yeah, and that's a crucial thing. So do you know what, Tanel? I've just had a message from someone saying that they found what you were saying so interesting, but they couldn't hear you clearly. I can actually hear you fine, but I'm gonna get you to write up some of this stuff really briefly and maybe stick it on my OWL Parliament, because I feel like
I will stick everything in
stick it there. Thank you.
I have nice yellow stickers.
Yeah, put it there in yellow. So yeah, so I mean,
what we have a problem with the sound. I
can hear you okay. I don't know if the rest of you guys can
change something in my configuration, because I'm not very expert.
Don't change anything. I can hear you good, and Massimo says he can hear you fine as well. But I think I'm gonna ask you to write it up for us. So anyway, so the rest of B, what is the definition of a frontier worker in the UK? Is it basically what we've been saying?
So I think I have the easiest task of this panel. So I'm going to explain it because it's just the UK rather than sort of wider Europe. So I'm going to explain it by way of an example, and that is, think of a French citizen, a financial director working for a multinational organization, and he splits his time between the Paris office and the London office. Cross-border work, commutes into the London office because it's there. And I think the reason that this has been made so much simpler is obviously cheap air travel, although we don't know what it's going to look like post-COVID, and quick commuting routes into the UK as well. So in terms of the Frontier Worker Permit, it went live on the 10th of December last year. And the reason for it is that it allows EU, EEA and Swiss nationals who are workers and self-employed workers who are primarily residents overseas outside the UK, but wish to work in the UK, so commute to the UK for work. That's the UK's definition of a cross-border worker, basically.
All right. And I think a super important point here, actually, that Tanel mentioned as well, is that it's for both employed and self-employed people. So it's about the state of somebody being employed, even if it's by themselves. So that's an important thing for people to understand, I think, right?
So let's just flip it the other way as well. So with a self-employed worker, we've got an Italian citizen living in the Republic of Ireland who works across the way in Northern Ireland for construction work. So that's an example of a self-employed worker.
Yeah, it's really helpful. So Agnieszka, how about from your point of view? Is this what you're seeing in Poland as well? Does that definition ring true to you?
In Poland, I would say it's quite easy definition, and the frontier workers are considered EU citizens or British citizens who reside in one country and perform work in other country. And it can be employment, it can be self-employment, it can be any gainful activity, business activity. And the frontier worker permit came in force on the 1st of January this year. Mm-hmm. And for British citizens, Yeah. And I would like to distinguish that we have, like, for example, with Ukraine, we would not say that they are frontier workers. They are neighboring countries and different regulations apply. So it's really important to distinguish that not every
not every cross-border worker is a cross-border worker.
Yeah, exactly. Yeah. Not every cross-border is a frontier. Neighboring countries in Poland and frontier workers.
Yeah, this is important. And then Sybille, from your point of view, and also I might just throw in here as well, when we're talking about what a frontier worker is or what a cross-border worker is and who one is, let's also start to think about why we even care, So, but what's your definition, or how do you think of a cross-border worker or frontier worker?
Yeah, that is interesting, because I think a lot of companies and a lot of employers have started to formalize the status of their employees, UK nationals working in Europe and European nationals going to work in the UK or currently working in these countries, to ensure that they are in the possession of the correct permit. But the frontier worker is not very well known. So I understand what you were saying in the beginning. It might be for a lot of people some very niche information, and they think it's not really applicable to them. But when we prepared for this call, we found out that it is really applicable for a lot of employers, and that would be something interesting to consider now before the end of the transition period, not the transition period, but the end of the period where you can file the application is over during this year, so that employers really look at it and say, do we have people who we would consider a frontier worker? Because I think in the beginning we were saying we consider frontier workers as a cross-border, like someone going from France to Germany overnight, but this is not the correct definition, because we do have people going from one member state to the UK, for example, which is not a neighboring country. And I think that's something that is we need to identify as an employer as well, and keep in mind that we could have employees who would qualify for that kind of permit.
Yeah, perfect. Thank you. And I've got another kind of question here that's come up in the chat or the Q&A. I can't remember which one now. But how about place of contract? Does it make any difference if we're talking about a frontier worker, somebody who lives in one place, resides in one place, works regularly in another place, could be employed or self-employed? Does it matter where they're employed, where their contract is held? Does that make any difference to anyone?
Look, first, it's better to frame again the concept of frontier worker under the withdrawal agreement.
Yeah.
There is no, under the withdrawal agreement, there is no definition from national legislations. There is only one definition of frontier worker, which is from Article 9b. And a frontier worker, it's a worker who is working in one or more member state in whose territory he's not residing.
Yeah.
This is A. B, that does not mean that he may not work also in the country where the frontier worker is residing. Yeah. And that would shall answer the question more or less. So let me bring an example. Global employment. So we have a beneficiary of the withdrawal agreement, so a UK frontier worker who before 31st of December 2020 did the same, and after we do the same, let's set it aside. Employed, let's say, by the same employer or two employers in Belgium, 30%, and residing in Belgium, and 70% in the Netherlands, employed by the same employer or by two different employers, and residents in Belgium. So under the withdrawal agreement, in Belgium, he will be eligible for a permit in the capacity of UK resident worker beneficiary of the withdrawal agreement, and in the Netherlands for a permit as a frontier worker. So he will hold two permits. And if we have another country additional to the Netherlands, he may hold X permits in the cup. So we have this definition, which is extremely clear. And by the way, it's clear, precise, unconditional, and does not require further transposition measures. It's not, the question is not what the law in Belgium, Poland, UK, Germany,
Netherlands, Luxembourg, wherever.
Withdrawal agreement, it's the definitions that we have under the withdrawal agreement, and it covers, it's quite wide. Then if it's about TCA, then of course we do not have a definition, because simply the frontier workers will be must be seen from the perspective of the national legislation of the country where they work. And here it's quite complex. I mean, on the EU level, we have two different general scenarios. And here is very interesting. One is, so UK will be a third country, okay? So we are not talking about beneficiary of the withdrawal agreement. So we are talking now about a UK national having the same status as a EU national, because the activity has been initiated, let's say, on 1st of February this year. So we have stay in a member state which beyond 90 days in any 100 days period, okay? Which can be stay based only on an authorization of work unless exemption, and not a single permit. And that it's a kind of frontier worker. And we have frontier, we have the second kind of permit, which here it's a third country national residing in one member state and working in another member state. And here we can have the situation of frontier worker, which can eventually return home only once a week, because returning home only once a week to a home which is located outside of the EU territory, it means staying beyond 90 days in any 100 days period. So this would be the second kind of frontier worker, which resides in the one EU country and work in another or in several. So, and here there are quite I checked different legislations, there are quite a few confusions. In Belgium, we have, even between the Flanders region and the Walloon regions, the definitions are really different. And it was very, I mean, in one we have neighboring country, another one we don't have neighboring country. In one we have working maximum 90 days. In the other one we have 90 days in any 100 days period. So here it's really depend from one member state to another.
So it's not at all surprising that it's confusing, basically, because there's more than one definition sort of floating around out there. You know? But from the TCA, so if we think about the TCA, we think about Brexit, and we think about what we're trying to focus on today, we're talking about people residing, UK nationals residing in the UK or one member state and working in another, but residing in one, working in another. So Gabby, to your question that I've just seen in the chat box, what's the difference between a business or a project-based traveller? A business traveller is not working at all, they're on a business trip. And a project-based traveller may not be residing one place but working in another. That's probably more likely to be a short-term work scenario, I think is the answer to that. But anybody jump in if you want to add to that. But Sybille, I was going to ask you, why do we care, and from your perspective, trying to organize a whole bunch of people who are trying to travel and work and live in all sorts of different places, why does it matter? You know, why do we even need to know what a frontier work permit is? Or, you know, it should not just be an academic discussion, right?
That's correct. No, I think it does matter in many factors, because the first one we are talking about is the Brexit implication. Now that we have an advantage here, that we can apply for permits now for everyone who has been residing. And maybe we start with the UK first, because like Bea was saying, this is the easiest part she's having, and there's only one country to cover. And if we are looking at the UK, if European nationals going to the UK, employers are very used to have European nationals go to the UK, and we have to change our mindset that not everyone is now considered a European national any longer, or can easily go to the UK. So that has to change after all these years first. And then we have to see what do we need to do. So everyone who has been working and living, or not living, but working in the UK prior to December 31st, 2020, is eligible for a frontier worker permit now under this withdrawal agreement. And they can apply for it, and that will save us time in future if we would have, if we would only file the applications then at a later stage, we would not fall under that special category, and then we wouldn't save time, but we would need to file for a normal cross-border work permit, which would take even longer. And now the authorities allow us for exceptions. And I think the questions employers would have, I mean, everybody was looking at finalizing the status of European nationals so that they are compliant with the immigration regulations in the UK. But looking at a frontier worker permit now, what would be the advantage for an employer if looking at existing employees and new hires, if we are looking at them, is the permit issued for an unlimited duration? Is it connected to an employer? What is, Tanel was waving his hand.
We should look at the UK first. Let's look at the
UK first,
yeah. And you're right. So, well, yes, again, I have the easy task. So all very, very good questions. So the frontier permit specifically is for those who sort of fall between the gaps, I guess, where EU, EEA, Swiss nationals, and Irish, incidentally, as well, who can apply if they wanted to, but it's not a necessity because obviously it's part of the common travel area for them. But yes, so applying for the frontier work permit, there are certain criteria that need to be met. So let's start off with that first of all, and that is if they were a worker in the UK by the 31st of December 2020, then they would be eligible for the frontier permit on the premise that they spent less than 6 months in 12 months, or if they spent more than 6 months in the UK, then they visited their primary residence in the EU or outside the EU at least once in 6 months or twice in 12 months. So that's the key criteria. Now, one of the pros is there's no cost involved or associated with the frontier permit. It's valid for up to 5 years for a worker or a self-employed worker, provided evidence of a contract, payslips, and maybe even bank statements linking back to the payslips can be provided. It doesn't lead to settlement though, so there's no indefinite leave to remain on the frontier work permit, and you can't bring family members either. So obviously that's a negative as well. The EU worker would need to source, another form of entry to the UK. But on the premise that they meet the frontier requirements for the employer, it's quite an easy win, I guess, because they can come and go as they please, and it's renewable after 5 years as well. There are some exceptions.
Do they have to have a certificate of sponsorship type thing? Like, does the employer have to be all registered and set up and all of that type of stuff to issue them?
No, so this is the benefit because it's the individual that's making the application.
Yeah.
So I can give you some examples. I mean, we've applied for these frontier permits already. Whilst there's a grace period at the moment where individuals applying for the frontier permit, they don't need to apply up until the 1st of July. Effectively, it's mandatory from the 1st of July this year. So the grace is until the 30th of June. There's no cost associated with it, as mentioned. There's no sponsorship. So it's the individual's permit. It's held directly by them. So that's the benefit, I guess. So the costs, the skilled worker can be quite overloaded if we start going into that, but we'll save that for the next webinar.
Yeah. So from your point of view, in the UK, it's quite quick. It's free. You don't have to have, the employer doesn't have to be all registered and set up as a sponsor and all that kind of stuff. But you can't bring your family members, can't get permanent residency, so swings and roundabouts really. Yeah.
It is. And, the process as well, it's quite streamlined. So the process of the application is that it's all online. All Home Office applications pretty much are now online. And there is something called an IDV app that the Home Office has launched. So if the EU worker is already in the UK during the grace period, they can apply in country using the IDV app. So they upload a copy scan of their passport, their digital photograph, complete the online form, upload all of their documents, and it's issued within about 2 to 3 weeks. At the moment, we're finding the sort of straightforward ones. And what's received is a digital document with a reference number confirming that they have frontier work permit status in the UK. Alternatively, if you've got an EU worker who's applying from outside the UK, they can visit what's called a visa application centre, which obviously most of our audience are hopefully familiar with, and they will receive, they'll submit their passport at that centre with the biometrics that they submit, and they'll receive an endorsement in their passport. So there is a hard copy format as well. They can go for either or, and it's free.
Cool. Sybille, you were about to say something and I sort of talked over you.
No, it's okay. Thank you. I was just asking, or wanted to ask, you were mentioning it's an individual application. So if an employer doesn't have an entity in the UK, and they would send someone maybe to work at a client site, would that be considered frontier working and would be approved? Or do they have to have an entity and pay the salary?
No, so again, yeah. So again, it's so when we talk about worker and self-employed worker, if there's no contract, but there is a letter which resembles employment in the UK for the worker, that is sufficient in itself as well, with a confirmation of what sort of salary they will get paid, for example. That would be sufficient in itself to submit to apply for the frontier worker permit. So it's really, the terminology around it is really quite simplified and loose at the moment. Whether or not that will change, we don't know right now, if there is abuse of the system, but at the moment it's really quite straightforward. And also, just a point out in terms of salary expectation, so the HMRC has issued some guidelines associated with the Home Office, and for the financial year 2021 to 22, an example provided is that the salary expectation that the caseworker will apply is £183 per week, by way of example.
Quite easy
But
to
if you don't need an employment in the UK to have the status of frontier workers in the UK?
You need to have employment, but you don't need an employment contract per se. Okay. So it could be a letter formalizing some sort of work in the UK, but not necessarily.
But Sybille is addressing working at customer side. Working at customer side in general.
No, sorry. I was really, that was out of my interest. We were checking what do you need, and if you don't have an entity in the UK, for example, you can't provide a UK employment contract to the frontier worker.
You cannot employ someone within the UK territory? You can, no?
No, you can. Yeah, if you're sending them to a client site, you employ them wherever they're coming from.
Yeah, I was just asking,
sending them on an assignment.
In case a company doesn't have an entity in the UK, that was my question.
Yeah.
Another topic I would bring as regards advantages. I don't know, in the EU, it's frontier workers, beneficiary of the withdrawal agreement, are still beneficiary of Regulation 492/2011. All the rights concerned. So workers direct beneficiary and self-employment also the regulation applies by analogy. So that I think is a very important point, because if you compare the regulation 492/2011, which again would apply to frontier worker beneficiary of the withdrawal agreement, to the single permit directive, to the rights under the single permit directive, you have certainly more rights under the 492/2011 than you would have as a UK national holding a single permit
so from the individual,
in the member states, so there are certain real advantages in taking advantage of the status of frontier worker, if you can take advantage, of course.
And Agnieszka, you were telling us some horror stories about timelines for normal, from your point of view.
Not really horror stories, but because, after Brexit, since the 1st of January this year, British citizens, like first comers, are treated as third country nationals. So the procedures get more complicated, like for any other third country citizens. And unfortunately in Poland, especially due to the pandemic, but also really big immigration that is coming to Poland all the time, despite of COVID, the governmental offices are not very efficient. There are delays everywhere. And like a unified work and residence permit can take from like 6 months, in some severe cases even up to 3 years, because I heard about such cases, but this is probably because of some complications, and it also depends on the province. So you have to consider that if you can take advantage of being beneficiary of the withdrawal agreement as a British citizen, I would recommend to do it, to see the options, because with these exemptions, the frontier workers, the procedure is much quicker. It takes normally from 45 to like 2 months tops, and there is really little paperwork. Unfortunately, in Poland, we cannot do much online, so you actually have to submit documents in paper, and you have to appear in person because you know, you have to submit your passport. Also, there is scanning of fingerprints and stuff like that. So you have to be there. However, still the paperwork is really little. It is really very simplified procedure. And I found out today, which I especially checked, that you receive a card for 10 years, which is really worth doing.
Wow.
For 10 years,
yeah.
Yes. And also in Poland, you can do it till the end of the year, submit an application. So even at the last moment, which I recommend doing earlier, but you can in theory do it, there is still time to do it. And also this kind of permit is about performing work. It's not related to a specific employer. So you can change employers in between. You can start being self-employed. You can also start business activity. So once you have it, there is much more options, which are very limited for other third country nationals. So I think this is really something that should be considered.
So we're saying, if you've got employees who qualify to be a frontier work permit, it's going to be better for you as an employer to try and sort that status out, because it will be quicker and easier and cheaper, probably.
Yeah, exactly.
And it's better for the employee because of their employment rights and flexibility.
And I would like to add that again, this is not authority fees as well for these processes. And similar to UK, you cannot bring your family, so this is disadvantage as well. And you cannot settle. So this is again. But if you don't need to and you just want to perform work, this is really good option without many complications, you know, that otherwise could happen.
So we should just quickly clarify on the timelines as well and the deadline. So you just mentioned that in Poland you can apply up until the end of the year, up until the end of 2021. And I just want to say in many countries, the deadline is actually the end of June. So I don't want to go through, and actually I don't even know off the top of my head which countries are which, but I know that, for example, I think Sybille, you were saying yesterday in Germany, it's the end of June. UK is the end of June. You have to apply by, I think B was saying France, I believe, is also the end of June. But I think people should take it away in their heads that a deadline may be the end of June, although in some countries it's extended until the end of the year to make these applications. So can we talk a bit also about how you, I hate to bring it in, but I think we should talk about COVID. It feels awful to talk about COVID and Brexit in the same discussion, and I'm not sure my nerves can really take it, but I think we should, because what happens with people who are supposed to be living in one place and working in another place, but they can't because there's no flights and the borders are all closed, and you know, they haven't been able to do that for the last year. Are these people able to still? Yeah. Can
I just because I have a practical example, because I've been asked about it, you know, and the condition in Poland to be considered a frontier worker under the withdrawal agreement, there has to be continuity of work, you know, in a transition period, so meaning before 31st of December last year. And we have a case where, due to a pandemic and all kinds of circumstances, people who were actually British citizens who were working in Poland as a frontier worker without any registration, because it was still possible last year, they were stranded in the UK for many reasons. And we actually consulted with the authorities if it's not going to be a problem, because they were, for the last few months, not coming to Poland, and however they eventually will come. So the thing is that they will assess each case separately, but it's important that it should not be a problem if there is some contract, employment contract, or you know, if you are self-employed, some other type of contract or contract with a client, if you can prove that you were still bonded with this contract, they probably will grant this permit. So from Polish perspective, I think it should not be a problem, as long as you provide certain paperwork proving that this is continuation of your work in Poland.
Okay. Tanel, I think you're trying to say something.
I do have a question. This story of proving that the employment contract, which is still running, which is not terminated, it's still valid simply because someone was stuck home in UK, or does not matter where. I have difficult to understand. I mean, as far as from my understanding, we have an employment contract running. And again, we are talking about frontier workers. So residents, it should not be eventually in the state of work. So I'm working from the state of work. Coincidentally, because of the crisis, I'm working from home longer than I should work. The employment contract is running. How I need to prove that an employment contract which is running was not terminated? By the way, how do they know where I was? How do they know that I was working from the UK? I was working from Poland? Because until 31st of December 2020, we had still freedom of movement. No? So the question is where I was as from 1st of January 2021. We are only in March. How exactly? I cannot understand where is the question. I mean, how an authority, I'm coming with an employment contract which is valid, okay?
Mm. So Tanel, I think
UK passport. Where is the question if I'm working now from Poland, from Belgium, or from the UK, or from the US? Where this question comes into discussion, and how the means of evidence can be brought where I have a valid employment contract. That's all, and I have a UK passport.
So Tanel, I can certainly answer that from a UK standpoint. So there are exceptions that have been built into the EU exit regulations, particularly for the frontier worker, and it falls under Regulation 4. So with the exceptions that they apply is, and if you recall, I'd mentioned that you need to have been in the UK, obviously over the last 6 months, at least once, or been home basically, either once in 6 months or twice in 12 months. Now, if you haven't entered the UK due to COVID, let's use COVID as an example, you have a valid employment contract, you may have been furloughed, and you can't physically get to the UK, so long as you can provide evidence to confirm that your employment is continuing, so your employment contract is still valid, but you've been on furlough, and there is evidence to produce that you can produce sort of 2019 onwards, and the Home Office will write to you, because I have this specific example right now where I have a self-employed person who hasn't entered the UK because of COVID. He's in film production. Obviously, the film industry has taken quite a hard knock, as well as all other industry sectors as well. So he's not been able to travel physically to the UK. And therefore, that application has been considered under Regulation 4, and the frontier permit has been granted just for a period of 2 years. So rather than the full 5 years, under Regulation 4 and exceptions, they will grant it for 2 years, and then it can be extended and renewed for a further 5 years. So that's how it is in the UK, if that helps.
Okay, that is it's a non-conservative measure taken by the UK. I don't know, we do have such cases for the EU? I don't think so. I mean, I don't think that we have a similar, I believe not. Okay.
So I wanted also to come back to the duration of the issued document, because when we were talking about this in our call yesterday, Sybille, you had a really good comment about it, which is, if these documents are valid for so long, for 5 years, or, the Polish one is 10 years, then, these people are going to be hanging around in the countries where they've obtained these documents, and they might want to be changing employer. So, and in fact, this has just come up in I think Gabby's just asked a question about it as well, so if somebody has a frontier work permit, or if Sybille wants to hire somebody who says, yeah, you can hire me, I have the right to work in this country, look at here's my frontier work permit. What should employers, is that allowed? What should employers be looking for? And do they have to do anything in that scenario to hire somebody who's got an existing frontier work permit that they've obtained for a different reason?
Yeah, if I can, in Poland, there will not be such obligation. Once you get a frontier worker permit, you can change employers. You don't have to amend this permit unless some regulations change, because we never know within these 10 years, maybe there will be some abuse of law, and they'll decide they will, change the law, and it will not be so easy. For now, you don't have to do nothing. Once you have it, that is just a big advantage. You can actually change employers. It is really important, I think, to note that frontier worker permit is strictly for Poland. It allows you to work. It allows you visa-free entry to Poland, but it doesn't allow you to freely travel visa-free within Schengen area. So this is So this is like a national permit, and you have to know that as well. So it doesn't allow to work in other countries. However, you know, if someone has a need for whatever reasons to work in Poland, it gives a lot of option for a long time unless the law changes. So, and you don't have to do any amendments, because I was also even asking what, you know, what happens, you know, if the visa expires, like considering that they have the, sorry, not the visa, the card for 10 years, what happens if it expires? Then they would just tell me, according to current regulations, you just change, you know, like you make a new one. You don't apply from the beginning, you just make a change of the card or something like that. So some kind of a simplified procedure.
Yeah.
So really easy at the moment.
And I guess this is the whole thing. I mean, yeah, go on, Tanel.
You can change not only employer, you can change also status. From
yeah, you can change status. You can be self-employed. Yeah.
The Article 17 withdrawal agreement. So it's
so it's fixed, and it must be like that.
Yeah.
If it's in the withdrawal agreement, it's in the withdrawal
agreement. I would like to make one more comment, because I also saw some questions that there is a difference between, I don't know how it is in the other countries, but in Poland, you have to distinguish seconded workers from frontier workers as well. Because seconded workers, the contract is based abroad, out of Poland, and frontier workers, the contract is in Poland. So seconded workers is a completely different regulations.
But are you saying then for Poland, a frontier worker must have a contract directly with a Polish? No, right? Because they can be self-employed or... They
can be, but they have to prove some kind of a contract with the client or some kind of a paperwork while they are working, something that is bonding them for employment in Poland.
Okay, so a posted worker, somebody who's seconded to Poland by their employer, can't...
It's a completely different thing.
Completely different thing. And they can't get a frontier work, but even if they're being seconded or posted and coming and traveling...
No, because seconded workers are usually... seconded workers, first of all, they have employment agreement with some foreign entity. Yeah. The salary and the contract is outside Poland, and they're just being seconded to work in another country under the employment contract with a foreign entity in a Polish, you know, perspective. So it's a completely different regulations.
Okay, interesting. That changes things quite a lot, I think, as well.
I think what Agnieszka was saying is really important for employers, because a lot of UK nationals might think, I have a permit now for Poland, and this gives me free access to go to France over the weekend or to any other country to maybe do a business trip or something similar, or work in another country, because it doesn't give you free access to the European labor market just because you hold the frontier work permit for one member state. So that's what we discussed yesterday when we prepared it. You can apply for a lot of permits in every European country. You can hold multiple permits. That's what we understand, depending on how you prove it in these member states. But you cannot say I have one frontier work permit for Poland and that gives me access to all other countries.
Exactly. And that's what, Tanel, you had that example we were talking about yesterday, right, of where somebody could be working. And it's very common actually to be working some of the time in Belgium, some of the time in Netherlands, some of the time in Luxembourg. And if that person can prove that they are meeting the definition of frontier work permit in those places, then it should be possible for them to hold multiple frontier work permits for multiple EU member states.
First, they must be a frontier worker, and it should not be about posting. It's a difference between posting by a single employer and multi-state activity on behalf of single employer in different member states, which is a posting. And coordinated contracts of employment or global employment, or different contract of employment by different employer in different member states. And yes, a beneficiary of the withdrawal agreement can hold a work permit as a capacity of resident worker beneficiary in one country, and different permits as a capacity frontier worker in different other countries. And of course, that's the right, it's per country. I mean, as Sybille say, you cannot work with frontier worker permit from Netherlands in Belgium or in Luxembourg, but you can, if you have one in Belgium, one in France, one in Luxembourg, you can work as a capacity of frontier worker in each one of these countries.
So
but it's important not to confuse with posting, because posting it's totally different, and especially now with the withdrawal agreement and with TCA, it's simply not,
Yeah. And I think it's, you know, for UK companies, I think it's confusing. I mean, honestly, I find it confusing. I'm in the UK because the UK, you know, our kind of employment, the way that we look at employment doesn't really, you know, when you get a UK work permit, it doesn't really matter where your contract is or where you're, you know, the posting, am I right, B? Like the whole posting, not posting thing isn't really a thing here so much.
Yeah, absolutely.
I think we are talking. I mean, it's very interesting. It's. I think I will start having really a look in the UK law because it's. I think it's an intention. I would need to understand the concept of employment. I have the feeling that in the UK, you put on a first place who is paying you finally, which should be irrelevant. Who is paying you? I mean, it should be interesting because it's totally different from. I never had really a look into.
Well, there you see.
It doesn't. This is the problem.
This is the whole problem. That's why we had to leave the EU because we're special and different.
It's really. It's how. By the way, EOR are allowed in the UK, I presume. Yes, no. Employer of records.
Oh, from an immigration point of view, or from an employment law point of view?
From the immigration, no. It's from I don't know. From
employer of record does exist.
I don't know what you mean by immigration.
Yeah.
Yeah. So okay.
Yeah. So let's not get into employers of record. We'll be here. We'll literally be here
the UK. To have a look at the UK.
Look at the UK and tell us what to do, Tanel. So there is another point that I wanted to make. So we've only got about 5 minutes left and I want to kind of get around and ask everyone their kind of final recommendations. But there is a point which I suddenly realized, I don't know if I've made it totally clear, which is the whole definition of frontier work permit or frontier workers and cross-border workers. When we talk about Brexit, it really matters when this work started. So what we're talking about is people who've been doing this work or this type of residing in one place, working in another place since before the end of 2020. So presumably now, if you send somebody, if a UK company wants to, you know, have somebody flitting over to Poland or Paris or Berlin or anywhere else, I'm not aware of any Brexit-related frontier work permit arrangements that still exist, and vice versa. You know, you can't qualify for the UK frontier work permit unless you were already doing it prior to the end of the transition period, right?
UK. Okay.
Yeah.
It's the same for here, for you. I mean, there is no any post Brexit, post withdrawal agreement, post 1st of January 2021. There is no any post frontier worker UK permit. You have the national legislation in each country, and that's all. It's finished.
Yeah, exactly. So really, I think the big challenge, I can't believe we've run out of time. It feels like we've only been talking for 5 minutes, but actually it's nearly the hour now. So the big challenge, it seems to me, is there is undoubtedly a benefit for people to understand if their employees qualify as frontier workers or cross-border workers. The difficulty is going to be to determine if those people do in fact qualify or not, and also to identify who qualifies and also to get those applications in on time. And we were also saying to each other yesterday that although now it seems very easy in a lot of places, you know, possibly maybe a little bit too easy, we're expecting regulations or kind of scrutiny of these applications to maybe tighten up a little, maybe a little bit more documentation to be needed or that type of thing. But I am talking too much. So I want to ask each of you, we've literally got 5 minutes left. So can you in 1 minute say what would your recommendations be to any company in this regard? Tanel, you go first.
I don't have any recommendation to companies. I think they know what to do, and if they don't know, they will seek for advice. I would have a recommendation for the UK. You see, things are quite complicated. I strongly recommend to the UK to ask to join the EU.
Yeah, I strongly recommend to the UK to ask to join the EU. Thanks.
It will make everything.
Thanks for that.
It will make everything easy and simple. You see what I mean? It's so interesting what beats it's bringing, and it's totally different from here. So we have here EU, which is again, it's not really harmonized, but we have the UK with totally different story, and it makes it quite complex. So if the UK will initiate negotiation to join the EU, it will be.
Do you think they'd let us in?
Easy. Yeah.
Thank you.
I don't think the EU would want us back, Tanel. That's the problem.
You're breaking my heart. You really are breaking my heart. Bea, what's your recommendation?
So I think the frontier permit is obviously valuable if the EEA worker is coming to the UK, doesn't want to settle in the UK, doesn't want to bring family members. It's purely cross-border work, can enter the UK and leave as and when necessary. But of course, that's not going to work if they do want to settle in the UK, they do have family members, then the EU settlement scheme might obviously have been a better understanding or idea. But otherwise, from 1st of January this year, it's the skilled worker process that all EEA workers and employers need to abide by. So that will involve sponsoring employers applying for sponsor licenses and then bringing in EU workers to the UK. And incidentally, obviously, I think the only benefit with the skilled worker is, yes, it does lead to settlement. Yes, you can bring family members, but also, you know, there's a cheaper cost as well associated with it as well. So it's not as expensive for other non-EU nationals.
Okay. Sybille, what's your recommendation?
To employers.
For employers. For everyone.
Not to me to join the EU, because I can't.
No, I think that's what we discussed in the meeting now and the days before, is that the employers really ensure that everyone is in possession of the correct permit type, and to double check who is qualified as a frontier worker, because what we said in the beginning is it's a misunderstanding sometimes. Is it cross-border, just between two borders because you're living close to a border, or is that really applicable to your employees who are planning to live in one country and work in another country? And I think take the advantage, especially if you have employees going to Poland. You don't want to wait for a long time to apply for or to get a work permit approved afterwards. So that would be the recommendation, I think, for everyone, just to double check again if there's anyone missed out because employers didn't consider frontier workers in their calculation or in their review when they were checking compliance for their employees, that this is an option, and make use of it until summer or end of the year.
Yeah. And Agnieszka, final words from you.
My recommendation is that if you qualify, just take advantage of it and apply as soon as possible. I recommend not waiting to the last moment, because even with the transition period last year, we had some kind of a panic paperwork being done, and really like few days before the year. So to avoid that, to avoid some possible hassle, just do it. And I think there are many advantages. If somebody doesn't need or doesn't want to settle and wants to come back home, this is really a good opportunity this year to do it, and it's an exemption. And I think I recommend taking this advantage.
Yeah, totally. Massimo says that he thinks UK nationals should find EU. Are you offering yourself, Massimo, as a potential partner?
Sophie, a very 2 seconds.
Yes.
Without joking about UK returning, statistically, looking into the questions I receive daily, the main problem today employers, and not only employers, even employees UK are facing, is the confusion between the concept of residence under immigration law, the concept of residence under social security, and that habitual residence. We have habitual residence stay, and we have residence, and notably the residence, because there is all this story. Am I from? I mean, I was told that I'm frontier worker social security, but I'm staying X, and it's going beyond or not beyond 90 days. This the confusion between the two concepts, residence immigration and residence social security, raised some problems. Not to talk about tax, which is not my expertise, and I will not touch it at all, but that is also another topic. So so again, statistically, this is one of the topics which must be really clarified in order to make clear, especially it's an old topic, but especially now in the context of Brexit, there are many questions related to a misunderstanding of what I am, where I am residing.
Exactly.
I was told that, but I cannot understand now where I am residing officially in my, where is my habitual residence, where I am staying. If I am not habitually resident, but I am staying in a country, why I am obliged to hold a residence permit in this country? Why I cannot simply go in and out I want?
Yeah.
These are frequently asked questions in this time.
Yeah. So I suppose our final message should be to people to find their employees who they think may be frontier workers, and then to ask somebody, one of you guys, or to ask their expert providers to look at it and to help them determine if these people are indeed frontier workers and if they can benefit from these exemptions or this. Essentially, it's a notification really rather than an application, you know, because if they can benefit from these much facilitated applications, then they certainly should. And with that, we have now gone over time. So thank you so much. You are all amazing. And thank you so much for everybody for coming and for listening. And please do send us your questions. I think we've managed to answer pretty much most of the ones that we had live, but please do send anything else that you have later, either via LinkedIn or of course through the owlimmigration.com Immigration Parliament. And we will be super happy to help you. Thank you again.
Thank you.
Thank you, Sophie.
Thank you.
Goodbye. Goodbye.
Bye.
Bye-bye.
Thank you.